Are you facing divorce or de facto separation and don't know what the steps are? Are you so overwhelmed by the process that you can't think straight? Are you focused solely on the end goal, knowing what your property settlement is and knowing what happens to the kids instead of focusing on the actual process that you need to get there? If that sounds familiar to you, then this episode will be great. Even if you're going through the court process, today we are going to take you through every step that you may face along the way to take a little bit of the fear of the unknown away. We're going to talk about the moment of separation until you're finally done or the final trial. This is your roadmap, but please remember it's education, not legal advice. Welcome, Mum.
Hello, Laura. Hello, everyone. Please, today?
Yes, we're both quirky today, so we'll just have to mind that for us. And also, please excuse last week if anyone listened to our episode and noticed that in the last 15 minutes, I'm talking to myself. We had some audio technical difficulties and we lost Mum's audio. So
my fault. It was my fault.
Just thought you'd want to still hear the episode as best you could, and I just cut out the bits and just made it me talking to you nonstop for 15 minutes at the end. But it is still a very helpful episode, so hopefully you listened to that and didn't think I was a weirdo talking to myself. Just a reminder again to everyone, Mum is not your lawyer.
No.
I am not a lawyer. So today we're just taking you through the steps so that you can feel a little bit better about where you're going. Because it is a question we get asked, Mum. I'm up to this stage. How long is it going to take?
Yes. I think anything's easier if you know how long you have to go and what are the next steps.
That's right. So let's get to the jingle and then let's get started.
Hello, I'm Laura, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
All right, Ma. So the first step in anyone's divorce or de facto separation is the separation, the actual date. That's when it really actually starts cracking. And there are other steps that people can take in the lead up to figuring out when are you actually going to separate, but we're going to talk about just the other ones. Why is it important people know their separation date?
It determines the length of the relationship or the length of the marriage, and that can have an impact under Section 79 and Section 90 SM.
Does it also make a difference based on that separation date on what you earn afterwards or what happens after when you've separated for your property settlement?
Yes. The court looks at what has happened since separation. So if you've squirreled away money and done the right thing, the court looks at that. It's still part of the property pool, but it is a property pool to which you've made all the contributions or the most of the contributions. Similarly, if someone wastes a lot of stuff post-separation, that comes into play as well.
All right, so it's really important that you know your separation date.
Yes.
Okay, so that's the starting block, right?
And if you don't, or if you and your ex have a different idea of when the separation happened, like for most people, you move out, that's the separation date. But if you are separated under one roof, it becomes very tricky. And so you need to get buy-in from your ex as to what is the date. Try to put it in writing, maybe even send an email. By my reckoning, I think we separated on this date. What are your thoughts? Or what's your take on that? And get them to, and so you need to find out not only what you say was the separation date, but what they are likely to say is the separation date. So that can help you know what evidence you need to bring, particularly if it was much earlier.
Now, the next step isn't court. So that's a good news thing for everyone. You don't have to go straight to court. So we do try and explain this to you. We did talk about this a bit in our webinar recently. You can try and negotiate some of this yourself. So that's where most people start, isn't it, Mum?
Yeah.
Most people have had a go. I saw a lawyer on a TikTok the other day saying the cheapest way to do your divorce is to do the negotiations yourself without the lawyer's involvement and get the lawyer involved at the end. I saw one of the guys I follow, And a lot of people, Mum, just resolve it themselves without going to court.
All the way to court. That's exactly right. So that's lovely that you said that. And you don't have to go to court straight away. And the court really wants you to do what they call pre-action procedures. And action being taking someone to court, obviously meaning before you go to court. So they're very focused on negotiations.
So you could sit down with your ex if it was safe and try and figure out what's going to happen with the kids. And a lot of people do that, and or figure out what's going to happen with the property and the money. The only trap that I think people fall into in this I'm going to negotiate it ourselves trap, Mum, is that people think that they can sit down, write their own agreement, sign it, and then they think that it's
They're
done.
one and done.
So what do they need to be aware of with that trap?
So that doesn't give you your property settlement. You can work out your children's stuff that way and call it a parenting plan at both sides. It's not enforceable, but it might be all you need with your kids. But make sure you cover everything in it in case there's hiccups along the way. You might be able today, but you might not be amicable in the future. And then you're going to look at your document and go, did I put everything in there or not?
And with property, so if they just sign it themselves and then don't do anything about it officially, what happens there?
Well, the court basically says each relationship gets one property settlement each. It's not a proper property settlement unless the court has approved it or if you go and do one of those financial agreements.
So if you are negotiating by yourself, just be mindful that just if you get your ex and you to sign a piece of paper, it doesn't make it official.
No.
And I do tell this horror story all the time just to give people a little bit of a friendly reminder where they had 50 grand in their account, they split it in half, they signed a piece of paper saying, you got 25, I've got 25, that's the end of it. He went away, gambled it all, came back a year later and said, I want my property settlement now. She'd saved up more money since then, and then she had to give him some of the property again. So don't let that happen to you. And Mum, the case you always like to mention is
Farmer and Bramley. And that was the case where the parties separated. They didn't have anything much, so they didn't bother getting a consent for their property. He won the lotto. And then she brought an application and said, I want property settlement now. And the court gave her, I think, $795,000 out of the $5 million. So it's not over until you've got either that court seal for property or your binding financial agreement, which is just called a financial agreement.
Okay. All right. So you've tried to negotiate it by yourself, but you might not get all the things agreed to, right? So you may have to go to mediation. Now, what is mediation, Mum? Can you give us a little nutshell of what mediation is?
A little nutshell of mediation is basically discussion through a third person who acts like a kind of a referee or a filter or a facilitator maybe of your discussion. Because in my experience, unless you've had a really amicable separation, when you get to the points about which you disagree, you end up having the same kind of arguments you had when you were married or a couple. And so this cools the temperature a little bit. The mediator helps you look at it in a more dispassionate way, and they can help you reach agreement on all of it or those nitty-gritty things that you just can't get an agreement on.
So you can go to mediation for parenting or property or both?
Yes. You need to
people, which one's better, doing it both or just one at a time?
I think you need a family resolution provider. I mean, I know you do. The Attorney General has FDRPs. They are the only people who can mediate about children. And then with property, so mediating for children, it can be lawyers. I think you should always have a lawyer, and I know that's going to upset some of the other professions who do property settlement, but I do think a mediator who has a knowledge of how the Family Law Act works can reality check not just you, but your lawyer if you've got one as well. So I like to separate them because the longest mediation should go probably is a day, right? And that might be by the time you get in at 9, by the time you get out at 5, that's 8 hours, an hour for lunch, 7 hours. You are exhausted. And it's unlikely that whatever it is you do second is going to get your best attention. Okay, so I would rather separate them out. If you think the kids one's not very hard, maybe book a half-day mediation, and let that go. With the property settlement, we say, don't we, if there's absolutely no prospect, try a half-day first with it or have an option to make it a half-day if the other person isn't properly negotiating with you.
Yeah. And now fingers crossed, if you can get to a mediation and you can get your ex to agree to a property consent orders and you can get your ex to agree to a parenting plan or parenting consent orders, then you're pretty much done. You just have to file it in the court. Mum, electronically, you lodge it in the court. And then how long till they get a stamp?
It should only be about 6 weeks, I think. A registrar will be sitting there looking. Do you know, Laura, before we talked about if you can get your ex to agree, I think we've left out something really important. Sometimes it's if you can get yourself to an agreement as well, because it's unlikely they will fall like a set of bowling pins in the face of your wonderful argument.
So true.
Yeah.
So true. But we're focusing on the process today. We've done mental stuff. If you want to go into the mediation stuff in the mindset, go and listen to some of our really good episodes on that. Or you can do the course and we can help you step by step through that. But Mum, just in case anyone hasn't done any of this yet, how long does it usually take to get into a private mediation if you want to book one?
It depends how popular they are, I think.
Right.
Some of the very expensive ones have a remarkable amount of availability because people can't really afford them, but reasonable priced ones can be very busy. So just look them up in your state. And
you can go to Relationships Australia or some of the other Centre Care, I think, or some other of the free-ish, cheaper ones. They, however, can sometimes have a wait list up to 3 months.
Really?
So, or 6 months, depending. So just be really mindful of your timelines with that. If you are thinking we need to do mediation, move on that sooner rather than later because it doesn't just happen overnight. Mum, after mediation, if they still can't agree, what happens next?
Well, I still think there's scope for a little bit more nutting out, right? So I never just ended it then and go, oh, mediation failed, we're off to the next step. So you could try arbitration, talk to your lawyer or the other side about whether they're prepared to submit it to an arbitrator. They'll get an answer a lot quicker, I think usually in about 2 months, and it saves having a trial. Okay, but you pay for the arbitrator and you can continue to write offers.
So you mentioned arbitration. Is that like a mini judge doing your case without a trial?
Yes, it's like that. There's usually no cross-examination. The Family Law Act provides for people to go to arbitration if they want to, and the person that is the arbitrator can make a decision, usually based just on the documents you provide and maybe 20 minutes of submissions each. So it's like a little tiny sort of court. The arbitrator is trained, is usually someone quite senior in family law. They make an award, not an order, and then you register the award with the family court. And it's a really good way to circumvent the whole delay thing. If it's a little thing you're arguing over or if it's not a very big property pool and you need to just shorten the length of time you're in this disaster.
So is it the kind of things that you don't need someone to be cross-examined in a witness box where it's just a decision? Because there's no cross-examinations,
no,
are
there?
there?
No cross-examination. That's resolved for trial.
But
usually, like if you know the facts in their affidavit are correct and the facts, and they agree that the facts in your affidavit are correct, but you both disagree, say, on the interpretation of the law, then an arbitrator is a really good way around that.
So that could be a next step after mediation. If you're both, though, still arguing and there's someone on the other side or you're saying, that's not true, I didn't say that, or you didn't say that, or so then you probably continue negotiating.
Yep, continue negotiating. Always keep negotiating. Always keep trying to find ways around. And if you've been to mediation and you've got agreement on some things, those things in. So just maybe write a letter and say to them, look, it's a shame we didn't get everything sorted yesterday, but my take on yesterday was we agreed on these things, 1, 2, 3, 4, 5. Can you let me know if that's your understanding as well? And then we'll talk about what we don't agree on.
Now, we haven't touched on, and this, I guess, negotiations can stall, really, because someone's ex is either avoidant or manipulative and controlling. And if you're trying to get them to negotiate and they're just stonewalling you or they're somehow making up reasons to not continue negotiating, and that can sometimes happen before mediation as well, where they just avoid mediation. What strategies do you recommend for those people going when they're stuck?
When they're stuck. So first of all, don't let the other person dictate everything to you. So give them deadlines and make sure there are consequences, right, for the failed deadline. So if I want you to do this or agree to this, if not, then this is going to happen, and then follow through. Okay, so if they won't negotiate, if they won't make disclosure, you need to send them a notice of intention to file. It means a notice of intention to go to court. And you usually give them 14 days from there, at least 14 days, that's what the rules say. And then do it. Go to court.
Right.
Don't send those without meaning it, because if you don't do anything, they're not going to take any notice of your other deadlines.
So sometimes that works and they all of a sudden go, oh, no, I do want to go to mediation.
Yes.
And then you don't have to go to court. Another strategy, Mum, that we talk about, if you've done mediation, still not working, is finding law cases, family law cases that have been reported that you can show them and say, hey, look, this is a case that's very similar to our case and this is what the outcome would be. So people always ask, I don't think people, apart from lawyers, are aware of that, but normal people, even if they're unrepresented, could use cases.
Of course. And people don't know where to find them. Okay.
Yeah. So can you tell me, as a lawyer, what your thought process is to help someone when they're in a case? How do you to find other cases? What are your thought processes?
So I have in my head a number of, and most lawyers will, a number of leading cases on different points. So, for example, if it was a loan from a parent or is it a mortgage, built office case. And I have a number of those in my head. But you can find so much the cases on AUSTLI. AUSTLII. I keep up to date with the cases, the judgments that are coming down from the courts every week or two. So to the FCFCOA website and click on judgments and you can read down on some cases. It's in a way, it's quite reality checking for you. It's also, I mean, I know I never watch soap operas because all of these cases are soap operas, but it's interesting to see how the judges make their decisions. And particularly now, with those big changes in family law for children and property, a lot of old cases aren't applicable anymore. So we're all waiting with bated breath for the first decision on these difficult points, particularly if it's from a full court appeal or even from a high court.
So why is that different to
because of appeal, just every judge who's under that level, okay, so in Division 2, FCOA, who's not as high as the appeal judges, is bound by that decision. They can't go, oh, no, I don't agree with that. I want something else. No, that's the precedent. That's the one they have to follow. So if you can find Court of Appeal cases, and they usually have the letters CA after them, then if you show that to a more junior judge, I'm bound to follow it or give a good reason why not.
Or if you show it to a lawyer on the other side, or if you show it to your ex in mediation or after mediation's failed, it may push them along a little bit to go, oh, do I really want to spend all that money going to court?
Well, I used to have a whole bookcase of court cases behind me, of books. Now it's all online. But I used to say to my clients, every one of those cases, each of them thought they were going to win. But every one of those cases, one person won and the other person didn't.
That's right.
So you've got to be there. And one more thing, Libby, with cases, if you click on Law Site after you read your case, it'll take you to the most recent cases on that case, that case, and then you can see how the current law is. But don't get caught up just because your facts seem the same as another case. It doesn't always exactly follow. It's more the principles that you need to follow.
Okay. So that is something you can do that can make you feel better. Yeah. It can make you figure out whether or not you're on the right track. But again, a lawyer's been trained to interpret those cases. So don't think you're going to interpret them perfectly. The good thing is in our Q&As, Mum, you explain them a little bit and people go, I'm stuck in this situation if there are any cases. And Mum uses her weird brain that has it all filed away in there and she lists them out and we hand them on to you. So that's really helpful. Yes. And we did have for a little while on Patreon Cases Explained by Lynn. We still have all those videos. So I'm going to probably upload them into the course as well so people can watch them.
Yes.
So if negotiation fails, if mediation fails, usually the next step is you go and get a lawyer involved to get them to start doing some of the red hot pressuring. You can send that letter that Mum mentioned, the notice of intention to file. You can send that letter yourself. We also have that in our course. And sometimes that is something that makes them all of a sudden sit up and pay attention and go, oh, okay, I better negotiate. Sometimes it's not. And sometimes it does actually mean you go to court. So let's talk about what happens in court in case anybody is listening today who's up to that process. So what's the first step, Mum, when you go to court?
If you're separated or about to be and you need to get everything finalised and sorted but you don't know what to do next, or you're looking for a way to do your own divorce and settlement without spending thousands of dollars on lawyer, then you already know what you need to do, and that is to sign up and become a member of the DIY Divorce Blueprint. Empower, educate and equip yourself with the legal know-how and the tools you need to get divorced or de facto separated and finally settle. Work through this course at your own pace without feeling confused, lost, scared or overwhelmed of all the family law legal jargon and processes. Let us walk with you through this journey and show you a better way.
So what's the first step, Mum, when you go to court?
If you've decided to go to court, what you mean, put an application into the court for them to decide your case for you. That's in a shortest thing. That's what you have to do. When you do that, you get your document, you lodge it with the court, and there's a few little documents they need with it. And then you serve it, give it to the other side, and they're supposed to put their documents in.
Okay. So it's filed. It's usually an initiating application. This is in Australia, of course, and WA is slightly different.
Yeah.
Initiating application, your affidavit, there's a financial statement.
Yeah.
Depending if it's kids, there's a notice of risk and a couple of other things.
And if you're wanting interim orders, there's something different again, or there might be a questionnaire. So they're all there. Yeah.
Now, do people file for property and parenting, or do they file just for property, or can they file for property later after parenting's already in?
Wow, that's a lot of questions. So if there are parenting issues that you also feel have stalled, you might want to do property and children matters together and get them all before the court and pull that through in the hope that you'll resolve them or one of them before you get to trial. It's a matter for you. If you haven't got kids, or if the kids are fine and the relationship's fine, then my view always has been, if it's not broken, don't bother fixing it, so that you've got that flexibility of no orders. And because, the court, if you go and get orders and things change, you're going to hit that rule in Rice and Aspen and may not be able to file again. With property, you can do property on its own as well, like I said, on its own as well. Or sometimes people file an initiating application just about kids.
What if your ex files in court about property?
Yes.
And you have to respond? Can you respond with property and parenting?
Yes, you're seeking a different order in yours.
Okay.
And then they will have to file some documents about whatever it was they weren't talking about to start with.
I think it's really important here to note, just like the notice of intention to file that you can send as a letter to your ex that may give them a little firecracker under their chair to get moving, filing the initiating application and starting court proceedings can also be the firecracker under their seat to get them to going back to negotiate.
It's more like a bomb under their seat.
Yes.
If a judge gets hold of them.
That's right. So they're like, oh, goodness me, I haven't been doing disclosure. Oh, goodness me, I've been being really sneaky or being really badly behaved. And now this is going to be in front of a judge. I think I really just want to settle. So, Mum, do heaps of cases resolve after the initiating documents are filed?
Yes, a lot of them do. They resolve quite quickly. Or to the court makes maybe some preliminary things like, get these documents done. I order that you do these valuations, and things sort of get back on track.
So hopefully for any of you who get to this stage, maybe you can continue negotiations, you can go back to mediation, even if you're in court, you can try and get this sorted and get your consent orders locked in and done. But you may end up at your first court event, which happens around 1 to 2 months after you've filed those initiating documents. What happens in the first court event, and what do they call it? Sometimes call it a first return?
Yes.
No? What is it called?
Used to call it a first return date, which just means the first day on their diary, the court diary, that it pops up again, right?
Okay.
And now they call it first court event, which I don't think is much better, but anyway.
No.
On that day, they be able to attend electronically. Sometimes you have to attend personally. On that day, a registrar in the court of the court.
What's a registrar again?
Oh, they're like, I think, third from God. So you have your judges, in the appeal level 1, Division 1 judges. Yep, and then you have your Division 2 judges and judicial registrars, senior judicial registrars, people with some powers, but not of the powers. So you will go before someone who's got the power to order evaluation and the filing of documents and perhaps anything by consent. You're not getting a full. You don't really say much if you're not represented. If you're represented,
do they have the power to take your kids away in the first court?
No, they do not. They can't order you to sell a house. No.
Okay. So nothing really big and scary can happen at the first court event. It's not like you see in the movies where it's a trial.
No,
this isn't what happens at this event.
No, they probably can order costs against your ex if they're the reason you've ended up there. But yes, you can see their powers. They don't have the power of a full judge.
All right. So they check documents that you've already filed.
Yes.
And they basically create that plan to see what's moving forward. A reminder, you may end up on the triple P 500 or whatever it is. The
priority property pool, which is the $500,000 excluding super or less, where the court is trying to move that quickly.
Mm-hmm.
You may also be put on the Evatt's list, which is for family violence.
And then they speed run those a little bit better and look after them better. And so so really in this first hearing, the first event, they're just looking at safety, they're looking at documents, they're setting timelines and timetables for disclosure and valuations, like you said, Mum. If someone is being a pain in the butt not doing disclosure, this is where they'll be told you must do disclosure. And they also probably try and want you to continue mediating.
Yep, absolutely. Because the registrar is a full judge, they do have powers to order costs against you, and the orders that they make are enforceable, and you would want to disobey a court order by a registrar or anyone else.
Okay. Now, the next step after that, Mum, is any interim hearings. So what is an interim hearing?
If you've got an issue that you can't wait until the final hearing, that has to be sorted right away.
Would it be like parenting, seeing the kids, maybe someone's withheld the kids, or who stays in the house, or spousal maintenance?
Yep, medical treatment for the kids, schooling for the kids, money for you to live on, money for you so you can pay your lawyers, or if you've got a bank threatening to foreclose, you might want some orders back. So the urgent stuff that can't wait till the final trial comes on. That's your interim hearing. There's no cross-examination in an interim hearing. The court, what they call, hears it on the papers. So they read all of the documents. They listen to the submissions of you or your lawyer and the other person's lawyer and decision for those things to happen, just to keep everyone in a safe holding pattern that they can wait until court, the final trial.
And that can usually be about 5 months after you file?
If you've got a really urgent thing, either way, email the registrar of your court, list to you, and ask them to list it urgently and set out your reasons.
So if you have money issues or kid issues, or if there's stuff going on, silly stuff going on in the business, if someone's wasting all the money and you're worried it's going to disappear, then that's what those interim hearings are for. And we've talked about spousal maintenance and how to apply for it. And that's hopefully where you would, if it was urgent, be getting it in there.
Yep.
You can go and listen to our episodes on that if you're interested.
You wouldn't normally bring an interim application without getting some legal advice.
Gotcha. Because if you have an interim hearing, you get interim orders.
Yes.
So that means in the meantime until you get proper orders.
Yes, that's right.
Okay. So they're not forever orders. They're just temporary. These are your current orders until you get your proper orders.
Unless it says to sell the house, unless you've had to sell everything, sort of like I said, it's the stuff that can't wait.
It's putting you in a holding pattern so it's fair until you get to trial.
Yep.
All right. Now, they send you back to mediation usually, court-appointed mediation, and that usually recurs around 5 months after filing. Often that's when it can be really successful because everyone's done all the documents, everyone's filed all the information, everyone's looked at it with a fine-tooth comb for the first court appearance.
Yes.
So, Mum, what do you see happening at these court-appointed mediations?
Okay, so you will have that mediation with a registrar or a senior judicial registrar, or maybe a judge. And I had one with the Chief Justice one time. But that's unusual. If there's children, there'll be a consultant, a child expert there as well. What's good about it is that the person who's mediating that is from the court. And so they are much more authoritative and are able to reality check you and your lawyers and give some indications of where they think things are going. But also they report. It doesn't disclose what happened in the mediation particularly, but they'll send a report if they think someone hasn't properly tried to mediate, didn't make a genuine attempt. They can tick that box, and that may have an impact on property settlement later on. But yes, because it's in the court, because everything's been revealed, then it's beginning to crystallise what your entitlement is. And you will have had a letter, if you've got a lawyer, about how much it's going to cost you to go any further. And so registrars are very, very good at mediation.
And I guess it's a lot harder for your ex to play silly buggers if they're doing it in front of a judge or a registrar, because these are the kind of mediations that they would be dealing with all the time.
All the time. And really, you only end up in court usually if one of you is being unreasonable. And it's unlikely your ex can do anything that's been tried on a million times before. So these people are not fooled.
Okay. So fingers crossed for everyone listening, if you do end up in a court-appointed mediation or a conciliation conference or an FDR, they've all got different names, but they all mean the same thing. You get sent to a mediation in court, that you get a consent order and you agree. Mum, you say they give an indication.
Yeah.
Usually sometimes they say, you've got Buckley's. You really should just settle.
They probably like that, but, they may.
I've heard some people have emailed me and said they had to make decisions because the registrar pulled them aside and said, look, I've seen where this is going to go and it's not where you want it to go, so you should settle.
That's really good. Yeah. And
it's good and bad.
Well, you'd rather find out then than at the end of, if you're barking up the wrong tree, you need to find out then rather than all the way through to a trial when the consequences can be very hard. I think that there's two elements to it. One is the other side has to give a little bit and you need to be sure you're on.
Yeah. And really, I see a court-appointed mediation as removing the bench. I think it's taking that barrier away from the judge being up there and you being down there to you're all together.
Yes.
And there's a bit more communication as opposed to wondering what the judge is thinking. The judge will potentially tell you what they're thinking. Even though sometimes in trials, judges do tell people what they're thinking out loud.
Yes.
But in a court-appointed mediation, they're allowed to be a bit more forthcoming with their thoughts.
Yes.
The bad news is, though, some people may not come to an agreement in a court-appointed mediation. So the next step after that is a readiness hearing, which, according to the FCFCA plans, they say it's about a month after the mediation. What happens at a readiness hearing?
Okay. So if you hadn't been able to reach agreement or still outstanding issues after court-appointed mediation, remembering sometimes the court will send you to back to your private mediator because it costs the court to provide these mediators. Anyway, after that, it's kind of like the judge goes, it didn't work. That's what it didn't work, eh? All right. Well, here are your instructions for trial. So, and they'll have a look at the document if it's been a court-appointed mediator to see if both of you made a genuine effort. They may have some comments on that. But basically then, they're saying, have we got all the valuations? Have you all filed all your material? Okay. So I want you to do these things,
Yeah. So, and it's just that they're figuring out what are the issues left?
Yes.
What is left that we're still fighting over? What documents are we going to need to look at to figure out who's right and who's wrong or what's going to happen?
And do we need updated valuations or things like that? Yeah.
Yeah. So a readiness hearing is also not as scary as a trial.
No. Yeah. Unless you've been doing the wrong thing, you can expect a bit of a kick along. But
so it's just the court checking to see if you're ready for trial and giving you some steps to take before you end up in final trial.
I think that's why we call it that conveyor belt. It's like a factory conveyor belt. And you come to the attention of people along the way and they just check what you're up to. Yeah.
Yeah. They're just checking on you.
Yeah.
So then after that, Mum, around that, the family court's aim is 12 months after initial filing to end up in the final hearing or trial.
Yes.
We're hearing WA, one lady told us in the webinar it was 3-year wait, but I guess it depends on how long your trial is going to be.
It's much harder to find 5 days or 7 days than it is to find 1 day to slip your case in.
So if you've got a trial that's only going to take 1 day, then you're more likely to have it within that year.
Yeah.
But if you've got a trial that may take 4 days or 5 days, then it might be a 2-year wait.
And that's why it's such a good idea to nail down the things that you do agree on. And so you've got them in open correspondence. And so you're only asking about the stuff you can't agree on. And that might turn a 5-day trial into a 2 or a 1 day.
Now, this final trial or hearing, hardly anyone ends up at this, don't they, Mum?
Yeah, I don't know the percentage who end up there, but the percentage of people who end up with a judge making a decision is around 2 or 3%. Usually, there are so many people who agree on the morning of the trial. We call it at the door of the court. And it's such a shame that they've spent so much money and so much stress and then they settle outside the door of the courts.
No, it's good that they settle outside the court, but
is.
what you're saying, it's a shame that they didn't settle
do it
earlier.
Yeah.
Yeah. But look, sometimes it just takes one poo-poo bump, Mum. It just takes one.
I think the court wrote these new rules and this process in 2021 because of that phenomenon. And they realised that why people used to settle at the door of the court was that was probably the first time that had a good look at each other's numbers, looked at all the disclosure, and were able to see for the first time what the case was. So what the court has done is pushed all of that sort of stuff right to the beginning. In fact, before you go to court, so that each of you knows precisely what the other is after, and you can make that settlement decision if it's possible.
So at the trial, this is like the TV kind of stuff. That's cross-examination, giving evidence, having expert witnesses, like maybe a family report writer or a business valuer or a house valuer or who knows, you name it. All of that happens in the trial with the questions, and you get in the witness box, and all of that stuff happens there. The good news is if you do get to that stage, I mean, there isn't much more you have to do after that. You then just sit back and hope for the best. It is probably one of the most horrifying experiences anyone could go through. So I pray for all of you never to have to go through that. But if you do have to go through it, I guess on the bright side is you only really get to do it once, Mum.
Unless.
Oh, gosh.
Unless. So I always worry when a client does extremely well in the trial and you go, uh-oh, that other side's going to appeal.
Okay.
And it's another ball game. But at least you don't have to give you're not cross-examined or anything. It's usually just on the documents.
I didn't factor in appeal to the 40 minutes that we had for the show, so we're going to leave that one out. But that is an option that people can appeal, which means they disagree with the judgment, and then
on a point of law.
On a point of law, if they can prove that's a good point of law, then it does go for a retrial.
Yep.
Basically. Yep. Okay. We've looked at all the stages. We haven't looked at all the steps, but these are all the stages that people go through, and that can get them to getting a final decision, consent order or court order on property, and the consent order or a court order on children's matters. And there does seem to be so many steps, so many stages you have to go through. But I think it's really important. The reason I wanted to get this episode out is just to remind everyone, you don't need to know how to handle every one of these stages yet. No. You just need to focus on the stage you're in.
That's right.
And even though every single journey is different, if you speak to somebody on the street tomorrow who's gone through divorce, theirs is going to be all over the place, completely different to yours.
Yep.
So you don't compare yourself to others, because really it does come down to, Mum, it's who your ex is, who you're dealing with, and how organised you are with all your stuff.
I think that's true.
Yes. If you're disorganised or they're disorganised and you do have to pry documents out of their cold, dead hands by going to court, then it is going to take longer.
It is.
But if everyone cooperates and does what they're told in an amicable one, you don't even need to step a foot in the court door.
No. And you need to remember, guys, you can stop it at any stage. So I always look at it, you've got your case going along the conveyor belt, but underneath, I'm mixing my metaphors here, like a little mix, you can negotiate. Okay, so you're a duck on the conveyor belt, but underneath, and at any point, you can reach settlement. And everyone is focused on that. All of the court things are focused on that. And you will get through it. I think the people who have the hardest time are the people who don't start the court. And so they leave themselves in limbo for so many years. And I think the reason I was really happy you came up with this topic, Laura, is people think when they start a proceeding, it's instantly going to cost them $50,000, $60,000, $100,000, but it doesn't have to.
And let's be honest, if you get all the way to trial, it could cost, if you take lawyers with you and it could cost you $250,000. I've heard of $750,000. I've heard horror stories. But like you said, Mum, you could file your initiating application in court, that first step.
Yes.
And then they'll agree.
Yes.
And then you technically went to court, but you didn't go all the way to court, and you're not spending all of that money. Or you could end up at the court-appointed mediation and settle. So it's not the end of the world. And we talked in our episode last week about getting stuck.
Yes.
And I see people getting stuck at those 2 points in 2 stages. The first stage they get stuck at is before mediation. they haven't gone to mediation. And then the second time they get stuck is just before anyone files in court. So they might have seen a lawyer and that lawyer said, look, your ex is being stubborn as heck. You're going to have to probably file. And then they just get stuck there and they sit in that for a while. So there's those two stages that really can get people stuck.
Yes. And I think one of the factors that feeds into the mediation, if it's you that's reluctant to go to mediation because you haven't got full disclosure. And I think people get stuck there and we're surrendering your progress of your case into the hands of the other person who's got probably zero interest in resolving the case. So, yeah, it takes a bit to get going, but the court has ways. But you have to ask the court. You have to get them before a judge.
If you're the one who has an ex who's manipulative, controlling, avoidant, or high conflict, and it's forced your hand to get them into these other stages, these later stages, does the court pay attention to that?
Yes.
Is there penalties for being the pain in the bum reason?
Yeah. So it's one of the factors the court looks at during working out property settlement, the behaviour of the person throughout the hearing and trial. But also at every court event, there's an option to ask that the other person has to pay some of your legal fees because so we call that or ask for costs against them. And the argument essentially is, Your Honour, we wouldn't be here except they wouldn't cooperate. And now I've had to come to court. They should pay the legal fees. So those kind of penalties, those consequences, not a lot of people realise it can have an impact on your property settlement because a lot of what happens with finances is actually use, under Section 4AB. But yeah, a lot of people, once they get hit with a cost order or a threat of a cost order once, they tend to behave themselves.
Yeah. And sadly, along court conveyor belt in this journey, there is legal abuse and coercive control to navigate for some people as well. And we've got some episodes on that you can listen to as well. I know this one wasn't really insightful. It was more of information giving just to show you this is what the stages are that people go through, not the steps, because there's a fair few steps in between all of those stages, but at least you know what the potential road is for you, and maybe that will take away a little bit of the overwhelm. And again, like we said, please don't focus on the end product of getting divorce property and kids stuff sorted. Focus on the process that you're up to. Focus on the stage you're up to, and it will take away a little bit more of that overwhelm and that depression. Mum, can you give us something to embroider on a cushion?
Okay. Tell it to the judge. Because if you are not getting any cooperation from the other side and they're being silly, right, you really do have to dob them into a judge to get some consequences going for them. Okay, so tell it to the judge.
Awesome. Just a reminder, our course is open for enrollment at the moment. If you're in the pre-court stage, we show you how to stay out of court. We show you the steps that you need to take in these stages so that you can get your property and kids stuff sorted and your divorce sorted if you need to as well. If you're interested in that, we close doors on the 25th of February. If not sooner, you can have chats with Mum. You can come along to our Q&As weekly. It's a really great community, and we'd love to support you on your journey through these stages. If you're interested, you can go to thedivorcecourse.com.au/enroll to find out more.
What fun. That's good.
Thank you, Mum, and we'll see you guys all next week.
Bye, everyone. All the best. Bye, Laura. Bye, darling.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.